Welcome, welcome. If you were here for last week's training that Jeremy did on the buyer advisory, you'll note that it has very much the same format. I think imitation is the sincerest form of flattery, so I stole most of his slideshow and jimmied it over so that it works for the seller advisory. So apologies if you're looking for something fresh and brand new. It's going to be largely the same, but tailored for the seller advisory. That's what we're going to talk about today. We'll start in about a minute. Start at 10 o'clock on the dot, and we'll start talking about the seller advisory. Good morning. One minute left to go, and then we'll start this thing off officially. If you've got questions throughout the course of this, you can toss them up in the chat itself or in the Q&A. Either one, I'll be able to answer. I don't know if there's a difference between the Q&A and the chat as for our record keeping, but take your whichever one you prefer. So it's 10 o'clock on the dot. Let's get this thing started off. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. I had a hand in drafting the Oregon Realtors forms, and I did the updates on the advisories. So I am going to talk to you about the seller advisory. Seller advisory itself, you see this is the first page of it, this 2023 seller advisory. If you've been using it in the past, it's the same advisory that you had in 2022, 2021, and so on and so forth in the past, with minor updates over time. We add things, we remove some of this stuff that's not relevant anymore. For example, there was a section in the 2022 advisory that talked about flood hazard insurance or something. No, the fire hazard zones from that past law that got kicked down the road, so that was removed from the advisory. So over time it changes, but if you've been using the advisory, the core information is still roughly the same. Today, what we're going to talk about is we're going to start talking about where to find the seller advisory. Then we're going to talk about why you should use the seller advisory, when and how to use the seller advisory, the structure of the advisory, some selected topics, and then a Q&A session at the very end for anything that you're still wondering after I cover literally everything in this training. So we'll start with where to find the advisory. If you go onto Oregon Realtors itself, or oregonrealtors.org/protect buyer seller advisories, or if you just Google Oregon Realtors buyer seller advisories, we have them available on the website. The buyer seller advisory, it's just a click button that links you to a PDF. Alternately, you should have access to them on your Zip Forms, your dotloop, or your SkySlope. It is worth noting that when we talk about this, I'm going to pull up our Dropbox that's on orforms.org. You can get to this Dropbox, but the advisory, there are two versions of each one. There is the Buyer Advisory PDF and the Buyer Advisory Simple Web version PDF. If you look up I'll just Google it right here for people, Oregon Realtors Advisory, it pops you to the first thing you can click on is this guy, which takes you to exactly what I had that snip from. So if you're looking for the advisory, the simple web version, it's right here. I believe on SkySlope and ZipForms and dotloop, we still have the other version on. That may change over time. The difference between the two is we have the Oregon Realtors Advisory. This is for the buyers. You'll notice it's 37 pages long. And once you get into the actual document, it's got this little section for initials down here at the bottom on each page. The simple web version, the one that you get on this website, the simple web version is 27 pages long, and it doesn't have that little initial space. The text is smaller, the formatting is slightly different, so it doesn't have as large a space between things. If you've got clients that are have trouble reading documents, or they want more white space in their documents, this one is broad. It's a larger document, that the text is larger. If you're worried more about how many trees you kill when you print this thing out, you can use the one on the website. It's much smaller, and it also doesn't require the initials on every page. The initials are not required. They're for your protection and for your benefit. But we heard from a lot of people that they didn't like having initials at the base. So this document that you find on the website, no initials. You don't have to do that. It still has, we'll cover this at the very end, the very last page of the website version still has that acknowledgement on it where the party says, I recognize that you gave me the document, but it doesn't require initials. It doesn't have a space for initials on every page. So That's where to find it. You can either find it on the website, Oregon Realtors Advisory, and it'll pop up, or on your forms platforms, and it'll be the buyer or seller advisory respectively, 10.1, 10.2 if you're looking for the exact numbers of those forms on your preferred platform. Why do you want to use the buyer or the seller advisory, not the buyer advisory? The seller advisory, first off, is to increase your client's knowledge and competence related to selling a property. In a lot of cases, you might have a client where this is their first time ever selling a home, and not a lot of cases. In some cases, you might have a client where this is their first time ever selling a home. If that's the case, they're not going to know a lot of the things that you might take for granted. The simple things like what an MLS is, your client might just not know that, and it's information that it's helpful for them to know, as well as there's other information in these advisories that helps the client kind of guide through the process. Things along the lines of, all right, you're going to have a buyer. They're going to put an offer on your property, and they're going to ask to inspect the property. That's normal. It's not out of the ordinary. If the client, that buyer says, I want to look in and see if there's dry rot, here's what a dry rot inspection would look like. It sort of gives an explanation of things to lower to remove the fog of war, as it be, for that client that's selling a house for the first time, or for that client that hasn't sold a house in a long time. That client might still want a refresher on some of this very relevant information in the advisory. The advisory demonstrates your value. It essentially provides resources that you're not going to get elsewhere. It's one of those things that Oregon Realtors provides for the realtors, and realtors are really the only people that are using these advisories. It's important because it's something that you can give to the client that is specific to your profession, that the client will see and go, wow, this is good information. I'm glad that I hired a realtor because they know this information. Theoretically, your client can always just pop on ChatGPT and say, how do I sell a house? And it'll give them some stock answer that says, like, first you put it on the market. And that's not helpful. This is customized documentation that's specialized for the practice and the actual sale of a property. And so a client might see this document and go, wow, this is really helpful. I'm glad I hired my realtor because they actually have this information they can bring to the table that is very useful for this transaction. It also helps prevent violations, claims of violations of your duties under Oregon real estate law, as well as NAR's Code of Ethics. There are a handful of things that licensing law requires you to disclose and kind of provide guidance for your client. You advise and counsel the client on various concepts, as well as NAR. The Code of Ethics requires that you don't just have somebody that hires you and you do very little for them, and then the house gets sold and you take a commission. There's something that you materially add. It's more in the preamble than anything else. It's in the actual Code of Ethics itself, where it says there's a standard of practice that we expect of realtors. There's things that we want you to do that we expect out of this industry, and one of the things you do is provide guidance, knowledge, and specialized information that you are expert in. And the advisory is a clean way of being able to say, here's the information that I need to provide to you. Here we'll walk through it, and it's a nice kind of listed way of explaining the concepts. It also prevents claims of negligence. We'll get to that a little more in depth, but this is a really important one. Negligence is a big problem at times because a client will sometimes say, my agent didn't do their job properly. And when that's the case, you want to have evidence to explain why you were not negligent. The primary reason for these advisories is not to stop a problem. More than anything else, an advisory exists for two prongs. It's to give the client information, but more importantly, it's to give you a piece of evidence that you can use in one of those disputes, in a court of law, in an arbitration, in a small claims court, any of those things that says, I did my job. I gave them information. I informed them about the risks. It wasn't me not following my duty. It wasn't me violating the Code of Ethics. It was the client not reading the document I gave to them. It's the client not asking questions when we went over the documents, and me not knowing that they simply didn't understand what counteroffer meant, that kind of thing. So this provides a paper trail, which is the most important thing you can have in a court of law, being able to say, I did my job and I can prove it because here's the document. That's why the advisory exists. It is your paper shield. Why do you want to use the advisory? Because there are elements of the disciplinary practice that in Oregon that will strike you if you don't use it. For example, this is 696301, grounds for discipline. Specifically, the real estate commissioner can suspend or revoke licenses if there are various problems, if the applicant has done certain things wrong. And one of those problems is that the client, the licensee, the broker, the selling listing agent has fallen below the standard of care that is expected in professional real estate activity in Oregon. This is essentially based on the community standards, and the community standard for brokers nationwide is that you provide advisories to a client at the onset so that the client can become informed and aware of problems that could happen down the road. That is just what realtors do nationwide because it's a pretty good method to avoid legal risk and all those other things. Because realtors do that as a practice, as an industry, It is part of the standard of practice. It's one of the things we do. And so if you aren't sending these advisories to clients, you are below the standard of practice. You are not fulfilling what the rest of your peers would always be doing in most of their transactions. And so use the advisory, because more than anything else, your peers are using the advisory nationwide. And that makes it the thing that establishes the standard of practice, and that means that you can be disciplined if you are not adhering to the standard of practice. The paper trail is the main reason. As a lawyer, I would say the paper trail is your main reason why you'd want to give this thing. But the other reason is it is part of your standard of practice, and you can get dinged if you don't follow that standard of practice. Beyond that, there's also the the pleading requirements is ORS 31-350, which is essentially if you're bringing a claim against someone for failure of some kind of a licensing requirement, essentially a violation of 696-301. The conduct of the real estate licensee, you need to allege that it did not meet the standard of professional care applicable to real estate licensees in the circumstances alleged. And if one of those arguments that the client brings is, they never even told me this was a thing that was risky, they never warned me that wire fraud could happen, how was I supposed to know about wire fraud? Everyone else is real. My mother sold her house and her realtor told her about wire fraud. That argument actually carries a fair amount of water in Oregon because of ORS 31-350, as well as other states where they have similar laws. Essentially what it means is you need to hold to the standard of practice, because if you don't, there is a cause of action that the client can bring against you. And one of the standards is the advisory. When we talk about negligence, this is usually what a client would bring. They wouldn't argue my realtor didn't meet the standard of practice. Dang, that's why I'm suing my realtor. They would argue my realtor was negligent and that caused me harm. This is the when we talk about negligence at law, this is essentially what we're talking about. I was harmed by X. I was harmed by wire fraud. My real estate agent failed to warn or advise me about wire fraud. My real estate agent had a duty to warn me about wire fraud as established by the standard of practice. That creates the duties of real estate agents. If it's something you all do, it's something that everyone should be doing, and it creates one of the duties of a realtor. And a reasonable real estate agent standing in the shoes of my agent would have warned and advised me about wire fraud. Therefore, my real estate agent was acting below the standard of practice in the industry, standard of care in the industry, and it breached their duty to me. My agent did not do what any other realtor in a new normal situation would have done. Had I been warned or advised about wire fraud, I would have not sent $100,000 by wire to a random number that I'd never seen before. That would have prevented the harm. Therefore, the agent breaching their duty by not warning me about wire fraud was what caused my harm. This argument is kind of the really kind of simplistic nuts and bolts of a negligence argument. This is what in a court of law would argue actually be brought in the arguments. The way to prevent a lot of this information, you'll note that the big standard in this is if they had warned or advised me about such and such, I wouldn't have gotten caught by it. That is where the advisory comes in. You can say, well, I did warn and advise them about them and that. And it's possible that the client might come back with another claim and say, well, you didn't warn me enough. I need multiple warnings. I am one of those people that a single yellow light does not stop me. I have to see multiple yellow lights before I even touch the brakes. Be that as it may, that's a different argument. But having the advisory in the first place is what begins to protect you from these negligence claims as a broker. We talked to a guy that does a lot of real estate mediations and arbitrations, one of the folks that works with ASP, and his statement was a signed Oregon Realtors advisory is oftentimes the first piece of evidence that is presented by the defendant real estate agent's E&O insurance attorney in a mediation or of a negligence claim. To demonstrate that the agent had met their duty of care to the client by properly informing them that the issue that gave rise to the dispute, they've been warned about it, and pointing them out where to seek additional advice. In essence, if you do have a negligence claim that gets brought to mediation or arbitration, your E&O company, one of their first questions is, did you send them the advisory? And if the answer is yes, you sent them the advisory, that's one of the things they're going to lean on. They're going to say, my client, my client, the broker, they warned this seller about the risks of wire fraud. They told them about it. They handed them a piece of paper. They talked it over with them. They said, if you have any questions, please ask me. They said, if you have any questions about the concept or the process for title, I'm not an expert in the title process, so here's a number to call the title company and ask them about their process for avoiding wire fraud. They gave advice. They told the client how to avoid these problems. That in its own right is a very powerful way of avoiding your own liability. And it's what E&O is going to lean on first. Before they even go into other facts or arguments or trying to point out specific problems that a client took on their own risk, anything like that, the first thing they're going to do is say, We did warn you. We gave you a document and said, read this and ask me questions if you have questions, because this is very important. And the client simply didn't pay attention to that, or didn't think it was important enough, or didn't read it. The reason why this is might sound a little odd to you is there is a paradox of your practice. In essence, you have the problem where undisclosed defects related to the property condition or the title of the property can result in damage to the buyer and might lead to claims against the listing agent for failure to disclose or warn the agent's buyer or the buyer's agent, or can become claims against the buyer's agent for failure to warn. On the other hand, the broker takes it upon themselves to, you take it upon yourselves to second guess your seller and inspect the property, you might be acting outside the scope of your expertise. So when you're a realtor, you have two masters that you're serving at all given times. You are the client of you are the agent of your client. The seller is your principal, and you are their agent. You have a duty to be loyal to that principal. You are acting in their best interests. But you also have the code of ethics and general kind of golden rule. Be nice to the buyers too. You're not just trying to pull one over on the buyers. And so you have a duty to disclose very real problems that can exist for that buyer. So when you're an agent, you have this dual kind of master that you're serving of, you have to make sure that you are doing the best thing you can for your seller, but also not taking advantage of the buyer by failing to disclose information or failing to do things that are that could, or to tell the buyer about things that are harmful. The usual way that this is addressed is you would ask the seller, hey seller, can we tell the buyer about the problems on this property? I'll put an example on this. For example, the seller has noticed that there is, for example, a hole in the floor, in the middle of their floor, and they just cover it up with a throw rug. If you, the broker, know about the hole in the floor, you're supposed to tell the buyer's agent, but you're not helping your seller out by telling that buyer's agent. In most cases, that hole in the floor is a material defect. It's something that should be disclosed. Giving the seller this advisory is a way of basically saying, hey, seller, be aware, if there are material defects on the property, you need to disclose those things. And I told you need to disclose those things. So be aware, if there's a hole in the floor, don't cover it with a throw rug, because you're going to cause problems for the buyer potentially. They could fall in it. They could get injured. Injuries could happen on the property, and that'll be your problem, seller. And if one of those things goes wrong, as an agent, you have served your client by giving the advisory and telling them what went wrong, and also the buyer essentially by saying, hey seller, you need to tell the other party about this information. And if you don't tell them about it and it's materially harmful, I might have to go outside what we're normally doing in this representation and tell them about the risks or harms to the property. The advisory is a kind of a clean way of splitting the difference while not necessarily violating your agency obligations to the client, and also being able to help the buyer out by ensuring that you're not lying to them. The best source of information, being the best source of information, is your best way of kind of addressing that problem of having to be a helpful party to both the buyer and the seller while representing one of the parties directly as an agent and representing the other in an honesty manner through your code of ethics. The advisories provide detail to make your client aware of possible issues that could arise. The advisories provide links and references to direct the client towards additional information and professionals. The advisories instruct the client to seek independent legal and financial advice if it is outside the scope of the agent's representation. And the advisories are a tool that helps the agent kind of find the sweet spot in that paradox by telling the client, you have an obligation, or I have an obligation to help you, but I also have an ethical obligation to be kind to the buyer and be honest and truthful and not to misrepresent things. Giving your client the advisory is a clean way of saying, it's not just me telling you need to disclose this information to the buyer. It's me telling you the standard of practice in the industry is disclose this information, and here's the reasons why. And if you have more questions, here's a lawyer you can talk to. With that said, the advisory is not a perfect tool. It doesn't solve every problem. It is simply, it is a thin paper shield, but it is the best paper shield you're going to have at this stage in the process. When and how to use the advisory. Essentially, you provide the advisory to your seller as soon as possible, typically at your initial client consultation. If you don't get it to them at that point, get it to them as soon thereafter. You want to give your client as much time as possible when they have this document to understand it, to ask questions, as well as it provides a shield for you only once you've sent it. So if your client has something go wrong in between the day you did your initial client consultation and the day you send the advisory, and the advisory could have stopped that, you don't gain the protection of the advisory because you haven't sent it yet. It doesn't matter that you sent it later. You need to it doesn't begin preventing problems for you until you send it. So begin your representation with an advisory. You want to continuously refer the seller back to the advisory whenever it's relevant. So if it's something about wire fraud, send them back to look at the wire fraud advisory or the section of the seller advisory that addresses wire frauds. If the client has questions about square footage, you can send them to the advisory and talk about that sort of thing. Generally, when you're relying on the advisory, you're relying on the standard of practice throughout the industry. It's different from when you make a personal statement and give an opinion on a matter. When you give an opinion, it is you that is on the line. When a statement is in the advisory, it's the standard of practice writ large. So for example, square footage. MLSs don't necessarily have square footage that's 100% accurate all the time. It's more like an advisory. It's a guidance figure. It's, if it says 1,400 square feet and the house turns out to be 1,450, so it goes. The advisories, it will tell you that on the MLS, the square footage is not necessarily accurate. If your client says, hey, with the square footage, do I need to go and really measure every single wall and make sure I know exactly how big my house is before I put it on the MLS? If you just answer, no, that's absurd, you'd never have to do that, and then it turns out you get in trouble for that statement, you made that statement personally. It was your opinion on the matter. If you just show the client the advisory, you say, hey, look at the advisory. This is standard of practice in the state of Oregon. This is how we address square footage. The client can rely on the advisory, and then it's not you essentially sticking your neck out and saying, my personal opinion is the following is the answer. It would essentially be you saying, this is how the state practice does it. This is what everybody else is saying for that same question. This is the answer that every realtor should be giving, and therefore, this is the answer that I'm going to give. It's essentially what the advisory says. It prevents liability for yourself by essentially saying I'm hiding behind the standard of practice as good advice writ large, rather than me personally saying something. Explain to your seller what the advisory is and provide a brief overview of it when you give the seller the advisory. You don't want to just toss a document to them and say, have fun, good luck. Send them the advisory and provide an overview, a summary, walk them through it page by page, walk them through it section by section, ask them if they have questions. That is very important. Something that's important for you as a broker is have your seller acknowledge they received the advisory on the last page of the document. That receipt of advisory acknowledgement, we'll pull it up later on as an example, but that acknowledgement is your paper trail. Being able to show, here's the advisory, here's my seller's signature on the last page that says I received the advisory. That, Your Honor, is how I can prove that I did my job by sending the advisory to the client. The acknowledgement is what says that they got that document. If you're using the version of the advisory, the seller advisory that has initials on every page, that is kind of a second layer version of that, where you can say, not only, Your Honor, did they sign the page that says I received the advisory, they also initialed the page that says here's how wire fraud works. They initialed the page on wire fraud. That's why I can tell you for a fact, not only did they get the advisory, but we went to that page that they specifically were on the page about wire fraud, and they signed it. They initialed the page when they got to the wire fraud page. So we covered that information, and I can prove to you that the client didn't just skip over it, or that they didn't just perfunctorily sign the acknowledgement. I can prove that we literally were on that page, and they are aware that we told them wire fraud is a danger. That's the purpose of the initials. It's why the main version of the document has the initials on it. It's to provide additional protection for a broker. It puts a thin paper shield in front of a paper shield. The advisory can be used regardless of whether the transaction will be completed on Oregon Realtors forms or OREF forms. If you're using the OREF forms, it is good to advise the client and say, hey, heads up, the advisory might be talking about specific form numbers. That's in reference to the Oregon Realtors ones. In OREF, we're going to have different versions of those forms. So for example, in the OREF forms, or in the advisory, we talk about buyer or seller pre-closing or post-closing occupancy. In Oregon Realtors forms, that's form 2.16 and 2.17. In the OREF forms, that's OREF 056, I think is the form for that one. I might have the number wrong on OREF, but it's a different numbering system, but the same core concept is true for those advisory forms. So the advisory is still applicable. It's just going to be specifically referencing the Oregon Realtors forms, not the OREF forms in the advisory. And lastly, the Oregon Realtors sale agreements, if you are on Oregon Realtors forms, they do require that you give your client the advisory, buyer or seller advisory, depending on who you represent. So if you're on Oregon Realtors forms, give them the advisory. They need this document. As for the structure of the advisory, it's broken up into 4 parts for the seller advisory. The first portion talks about listing properties for sale, is essentially a summary of it. The section contains information on how to interpret listing agreements. It explains what a multiple listing service does, and it gives additional context for square footage and acreage data that is displayed in the listing. Section 2 of the advisory for sellers is on the sales process. It's essentially all the things that lead into the sale and kind of what they are. It's information relevant to the purchase process, provides information on interpreting sales agreement forms and their addendas. It provides context on offers and counter offers on how they work, because sometimes you have a client that may not have ever done a counter offer on something, and this explains to them how a counter offer essentially operates. It says, heads up, if you get a counter offer, you can't just go back and accept the old offer because the counter offer rejects that old offer. That's done. There's no way to go back. It's a Rubicon crossing when you counter offer. It provides that procedure. It gives warnings about certain fair housing risks that can be brought into transactions. If you're a seller, love letters, for example, are that fair housing risk. We'll get more in depth on that. It advises people about contingencies. What are they? How do they work? Explanations regarding escrow and allocations of costs at closing. You might be surprised, but your clients, in some cases, have never heard the word escrow before. That's just, it's a term that people don't necessarily run into in their daily lives. And so escrow is something that you might need to have explained to the client, or you might need to explain it. In some cases, the client might not ask questions, but having the advisory lets them get to the information themselves. One of the risks that you'll always run is if you toss a document to a client, or if you just say generally, if you have questions, ask me. People are embarrassed to ask questions, and having a document that is non-judgmental in its explanation of information helps those clients who are shy or don't want to seem uninformed learn about this material in a way that they might not otherwise ask about. Escrow is a great example of that. It has descriptions of the termination process. How does termination work? What does it do? Why does it suddenly invoke escrow instructions? It explains the meaning of liquidated damages. That's important for sellers. And how that limits sellers' remedies in the event of a termination. And it has usages of first rights and how they modify offers. So what is a first right? How does it work? Section 3 is advisories related to the purchase sale agreements themselves. So the actual purchase and sale agreement has various addendas that are attached to it. What do we do with that? It contains information that, such as how do you deal with seller carried transactions, what is FIRPTA, how do HOA terms and for example, CC&Rs restrict things, explains what the tests and inspections are that a buyer might be doing. If the buyer wants to do dry rot tests, what's a dry rot test? If the buyer wants to do a radon inspection, what does that look like? It gives the seller a little bit of information on how to deal with backflow prevention processes. If you have water flowing in from a well and it gets contaminated and it backflows into the well, you've got problems. So backflow prevention is one of those things that we'll cover. It outlines details of the seller's disclosure obligations for various risks, as well as the procedures for repair and remodel and negotiations that might happen after a party is asking for repairs. It provides some explanation of what title issues could arise. It gives some highlights to how the seller's obligations exist on smoke and carbon monoxide alarms. Spoiler alert, seller, if you have a smoke alarm or a carbon monoxide detector, it's your job to make sure that that thing works before you sell the house. You can get in trouble if you don't. It states the seller's obligations with regards to the seller's property disclosure statement. Very important. Sellers, you have a property disclosure statement required by law. You need to send that. And it flags some things that the seller should be aware of in regards to environmental hazards or catastrophic loss of the property. What happens if midway through your transaction a meteorite hits and the property is gone? What do you do? It talks a little bit about that. Now, the advisory is not going to solve the problem. It's not like giving the seller an advisory stops the meteorite from ever hitting the house, but at least they'll know what the purchase process looks like in that event. The fourth section is advisories unrelated to the purchase and sale agreement. This is, for example, information about risks and liabilities that the seller might have from mixing the libraries of forms, from wire fraud, from audio or video recording information in the home or devices in the home, how homeowners insurance works, and some of the statistics that might be relevant to property that the seller might want to be able to point to or know about. More in depth, this is specifically what you'll find in the sections, and we're going to kind of rapid fire through these ones. So you've got in section 1, it talks about listing agreements, multiple listing services, square footage, and acreage. That's section 1. It's pretty short, pretty sweet, covers that information with a certain degree of depth. The biggest one in this section is explaining to a client what an MLS is. It's not, for example, most clients might go into it thinking your MLS is the exact same thing as Zillow. It's not. It's very different. It's proprietary. It's provided by the association that does the MLS. It's something that some parties may be on or may not be on. And depending on your access points, it might be more easier or harder to do certain sales or offers in various MLSs. The client might also want to know what the rules and procedures are for your MLS, and this kind of references that obliquely. So it gives the client a base foundation of understanding the MLS and listing agreements. If you've got a client that's never sold a house before, they might wonder what the heck a listing agreement even is. It's important for them to know that it's a paired version of a contract. It is both a agency agreement where you become their agent and they become your principal, and at the same time an advertising agreement that says, I agree to let my agent go and advertise this property for sale, and we're going to move down that road for the advertisement. So it's a paired document. It's agency stuff as well as a separate agreement that allows the agent to essentially advertise and move that property. In the sales process advisories, we've got offers and counteroffers. What are they? How do they work? The real estate form. What is a sales agreement? How does it operate? We've got non-customary documents and real estate love letters. This one we'll cover with a little more depth. It's the selected topic for sellers in this training. Non-customary documents gets a little funky because that term is relatively new and we're rolling with it. So we'll cover it in more depth. Don't worry. Talks about contingencies. How do they work? How does a seller operate with a contingency? What does a contingency do? What does it mean? What is escrow? How does it work? Allocations of taxes, costs, and fees. How do those operate? So for example, seller, you're going to sell your house. 3 days before closing, the city levies a fine against your property and asks that you have to rebuild the sidewalk in front of your house. Who pays for it? This explains the breakdown, the normal breakdown, the traditional breakdown of that, which is before closing, it's seller's problem. After closing, it's buyer's problem. So if you got notice that you have to rebuild your sidewalk 2 days before closing, tell the buyer about it in the first place. But also, seller, that's now on you because it's something that changes the property. It's an allocation of a cost that gets added to your side because it happened before closing. Default, termination, and the response. How does it work? What is a default? What is a termination? How do you respond to those things? What is this thing that we talk about with matching escrow instructions? Why are they important? We talk about it. We cover that in this section. Default is more kind of a concept in your Oregon Realtors forms. It is technically still relevant in the OREF forms. You still have the ability to tell someone, hey, you defaulted on the contract. Please fix it. I'm going to give you a couple days. If you don't fix it, I'll terminate. Same concept applies even if you're on OREF. We talk about liquidated damages. This is another selected topic that we will cover. Liquidated damages is not super relevant for buyers. Buyers aren't generally super concerned about this. The section is very different for sellers because for a seller, this means if something goes wrong, the most you can ever get out of this transaction is the earnest money. If the buyer in the middle of an inspection of the house kicks a hole in the wall, your earnest money is the only way you're going to be able to collect that if the buyer then terminates later on. If the buyer somehow causes damage to the property, you're only able to get your liquidated damages. If the buyer strings the seller along for 2 months and then terminates arbitrarily, you can't sue them for the loss of damages if the market improved drastically. Your liquid damages, your earnest money is all you're able to get as a seller. It's written into the contract, it's written into the law, and we'll cover that with a little more depth. We talk about first rights to a certain extent as well. This one's sort of doubled down on. First rights are a concept that some parties don't necessarily know or understand or run into. It's the idea of being able to modify a sales agreement so that a party has a lingering right to do something. If you are a seller, for example, a buyer can come up to you and secure a first right of refusal, which means if you ever get an offer on the house as a seller, you're supposed to send it to that buyer first and let them say, yeah, I like this offer. I instead would like to be the person that purchases. So pretend that was my offer instead. There's a process to it that it's quite legal. It is literally imposed by lawyers. We apologize. I'll apologize on behalf of the bar. First rights are relatively confusing to people that have never run into them before. And so an explanation of them is important because sometimes you just get blindsided with it. On the legal hotline, we get periodic cases where someone is, for example, in a divorce and the judge applies a first right of refusal to the property through a divorce settlement. And then a party who never knew anything about a first right suddenly needs to know what they mean. In this third section, advisories related to the purchase and sale agreement, this is where there are a lot of sections in this one. Information generally, we just kind of broadly talk about stuff. What is seller carried financing? How does it work? What about defective products and materials? What happens if you've got one of those wood siding problems? The wood siding has been recalled. What am I supposed to do? How do I address that situation? Residential tenant occupied properties. What do you do if you've got a tenant in the property when you're selling it? Can you just kick them out? Not really. It depends is the best answer, but the answer kind of is not really. What do you do with homeowners associations with covenants and conditions and restrictions? How are you supposed to address that? What do you do if you're a seller selling a house with an HOA where you're renting or paying money towards the community pool or something like that? What do you do? How do you deal with wells, well flow tests, cross connection and backflow prevention, all that stuff related to wells? What are you supposed to do if you're a seller? This provides advisory information. Some sellers, you might also find, even if they're the ones selling the property, know none of this information because perhaps they inherited the house. Or they are a trustee that has never lived on the property. There can be situations where a seller might just be absolutely absent any context or information about it, and they know nothing about wells, even though they're selling a house with a well on it. How do we deal with sewer and septic systems? What is the septic process? What are the lead-based hazard disclosure forms? That's important. Sellers have an obligation to disclose stuff with the lead process. That is a requirement under federal law. So this is 45 CFR 42 CFR 745 is the one that establishes the seller's requirements to disclose lead hazards. It's on the seller to do it, so they need to know about that. That's in the advisory. What do you do if you got a wood stove? The default, seller, you got to destroy a wood stove if it's an inefficient stove. If it's not certified by the EPA or by DEQ, seller, it's your job to turn it into a piece of unrecognizable slag. What do you do if your property's historic? That's important. Sometimes sellers might have historic properties that had a preservation plan that was fulfilled before the seller moved in and they're selling the house now. For example, the Goonies house, if you've seen those ones, the sellers bought it and then they sold the house something like 3 years later. They have not lived there very long. If you're still under a historic preservation program, you need to tell the buyers about that. If you're not under a historic preservation program, you should know at least a certain amount about the historic property so you can carry that information on to the buyer and say, heads up, buyer, this property is under consideration to be added to the National Register. This property has the following information that is true about it. This property was the site of the first cheese wheel that Tillamook ever created, something like that. There are all kinds of ways that property can become historic, and it can have serious tax ramifications if you're not aware of it, or it can have serious tax benefits if you're trying to invoke it. And so knowing that your property is historic or could be historic can be something that a seller actually has to disclose, and if they don't remember that or know about it, you should look into it. We talk about FIRPTA. If you're a foreign seller, a non-foreign, non-American, non-US person is the way it's officially defined, and you're selling property, there's additional tax withholdings that apply. You don't want your seller to get suddenly blindsided by the buyer withholding 10% of the purchase price because of FIRPTA. If that is the case, and your seller gets angry, in a lot of cases, the first person they come to and kind of whinge about it to is their broker. They say, how come I was supposed to sell the house for $1 million? I only got $900,000 out of this. What happened to the last 100K? And at that point, the broker needs to say, okay, so because you are from Germany, there's a special tax rule that applies here. It's called FIRPTA, and that's what we talked about when I gave you this advisory. You just needed to be aware, there are withholdings. Now, there's a process for getting your money back, and we talk about it in the advisory. So, you can go that direction, send a message to the Secretary of the Treasury at the federal level and say, I think the FIRPTA was wrong, but, we've told you about it. It's not the broker's fault that this person's the amount realized is not what they expected it to be because we told them about FIRPTA. There's also a similar version of that in Oregon for interstate sales. So if you've got someone from California selling property in Oregon that they own, there's additional withholdings and taxes that apply. And we talk about that to a certain extent in this section. We also talk about financing, professional home inspections, pest and dry rot inspections. What do they look like? Who might they be using for those? What's the process? What a radon inspection looks like? Why people do radon inspections? If you're a seller and you've never heard of radon, maybe look into your house independently because radon poisoning is bad and you don't want that. Mold, how it works, how it operates, what a mold test might look like. They might try and do a collection of some sort. Underground storage tanks, why they're important. You should know they exist if you've got one on your property because it can seep and that can create some serious environmental risks. So you need to know about those things. We provide some guidance. Environmental hazards and what they might look like. Omitted property taxes, what happens if there are property taxes that were somehow excluded or omitted and not paid. Repairs and remodels, what that process might look like if a buyer shows up and says, I want to do some repairs on the property. I want you, seller, to redo the roof. What are your rights as a seller? Can you say no? What does a repair look like? What does a remodel typically do? What do you need to disclose? What do you need to provide? Title reports and commitment. So what does the title report look like, and how does that process kind of lock in the meaning of the property? So a buyer, when they get their title report, what does it say? If the buyer doesn't complain about the title report or state their objections, what does that mean? It means the buyer is accepting the property essentially as is with the condition of the title as it was, which means if somebody has an easement attached to the land that lets them drive their truck across it to get to their hunting grounds, that moves with the land and the buyer knows about it. The seller should also be aware how easements work because they don't want to get blindsided by some quiet title action that the buyer brings. Smoke alarms, carbon monoxide detectors, it's on the seller. You got to make sure they're in place if the laws apply to your property. Risk of loss, what happens if a meteorite strikes, and common law disclosure duties, which is the things the seller has to disclose just because they're a seller, as well as the seller's property disclosure statement, which is the things you have to disclose because the law says so and the contract says so. Common law disclosure duties are separate from the seller's property disclosure duty statement, or seller's property disclosure statement. The common law duties to disclose are the things that are like materially damaging to a buyer. For example, a hole in the ground that you cover with a throw rug. You got to tell that to somebody. Your common law duty is not to let people get injured on your property. By contrast, the seller's property disclosure statement is the statutorily required stuff. Is the property hooked up to a water line? Does the property have a well? Does the property has it had a whole house inspection in the last 3 years? Those are statutory and contractual requirement disclosures. Common law disclosures are extra and beyond that. They're just the things that you should tell someone because essentially the golden rule. Section 4, relatively simple, relatively straightforward. You got the base form library, basically why you shouldn't mix forms, what the risk is of mixing forms, and how to address if you have forms that kind of mix between two libraries. This is applicable for new construction as well as the ORF versus Oregon Realtors kind of thing. If the client gets I guess for new construction, it's more for buyers, but if you've got a seller that, for example, is wondering what form library to use, this section will help kind of guide them through elements of that. We talk about wire fraud, we talk about video and audio recordings, homeowners insurance, neighborhoods, information about neighborhoods that you can find generally, as well as how you can find information on death, crimes, and external conditions of property, like whether it's in, what this used to have something along the lines of whether it was in a wildfire hazard zone, but that's not part of the law anymore because the maps are being redrawn. And lastly, it has just additional information, extra information. So that's the overview of the 4 sections. That's what the advisory has in it. It ends with the acknowledgement, which is basically your way of saying, seller, I gave you the document. And seller going, yep, you gave me the document. I will sign here and date it. That proves that you have handed me the advisory. And this is the most important page for your file as a broker because it's what protects you. Selected topics in here. We're going to go a little more in depth on some of the little topics here. The first one I'm going to point out on is non-customary documents and real estate love letters. Why do we have a section in the advisory on this? Because love letters and other non-customary documents create what is called a latent risk of a fair housing violation. If a seller rejects an offer after reviewing a love letter, there is a chance they did it because of a fair housing protected class. If the love letter had a picture of the buyer and the buyer's family, and you've got a seller who doesn't want to sell their house to a gay couple or a Chinese couple or something like that, then your seller has caused a fair housing violation. Now, OR originally put into law one of the seller's duties was to not send these documents across. Total Real Estate Group versus Strode from 2022 basically shut that down, so we can't prohibit the sending of love letters, but you are still, as a broker, encouraged to educate your clients about the risks of these non-customary documents and to inform your sellers that fair housing risks can be mitigated if the seller decides to not review love letters. If you tell your seller, here are the risks that a love letter poses, and your seller says, you know what, you're right. I don't even want to open up that Pandora's box. I order you, agent, as your principal, I order you to not send me the love letters. That's great. That's fine. You're not violating your agency duties if the client has expressly told you not to send that letter across. The client can do that. Just setting a blanket statement that says, I don't want to even receive or review love letters is sufficient from the client to allow you to kind of bypass the love letter process. Now, if your client says to you, you know what, you're right. I don't want to deal with these fair housing violations. Agent, I order you to not send me love letters if there are pictures of black people in those letters. That's a problem, and that's something that at that point you've got a separate issue where your client is essentially asking you to violate Fair Housing Act, and don't do that. But in general, a blanket rule from a client that says, I don't want to look at love letters, I don't want to deal with the fair housing potential, that is enough to allow you to say, oh, okay, we're not going to review love letters, I'm not going to open the document, I'm not going to send those love letters to my client. Oh, what are we accomplishing here? If the client knows, or at least you've given evidence that you informed the client about the risks presented by love letters, that helps you as an agent. It helps prevent the lawsuit from kind of blowing back on you if there is a fair housing violation. If the client's been informed about protected classes at both a federal and Oregon level, that lets the client kind of avoid causing those violations. By giving them the advisory that talks about love letters, we do talk about some of the protected all of the protected classes. So the client is at least aware, they are educated that here are groups you should not discriminate against. You know, don't make a decision based on someone's ethnicity. Don't make a decision based off their religion. Don't make a decision based off a person's race. The client, if they now know this information, they at least will know not to avoid those things. Now, it's really hard to convince a racist not to be racist, but at the same time, at least giving them the document is your way of saying, I told you not to make that decision. Why is it relevant? Because these lawsuits happen. Here's a case that happened, this is 2022, this one started up, and I'm not actually sure where it's gone in the courts. It's been paused at some point in Rhode Island. But it started in the District Court of Massachusetts, Ebony Clinton Brown and Todd Brown versus Helen L. Hardwick and John Hardwick. So Brown v. Hardwick is what the case is called. This is one of the case facts from the case. Miss Hardwick asked the realtor if one of the buyers was black because her first name was Ebony, and the agent said yes. Upon learning this, the seller said that the agent told the agent, I refuse to sell my property to an African American, and I want the back out of the deal with that person. That's literally a fair housing violation. Don't be a part of this. At least tell your client not to do these things, because you can say, okay, client, remember that advisory we read that said don't violate Fair Housing Act? This is a Fair Housing Act violation. I want you to be aware of the risk you're taking on in this situation. If a client says, I don't care, do it anyways, at least you can print out that email where you said, do you understand this is a fair housing violation? This is a very, very bad idea. We don't want to do this. This is not how it acts. And the client says, I don't care. Print that email, put it in your file. You've done your job. You are not going to get penalized for having at least done your job of saying you are aware that what you're doing right now is illegal. And letting your client make that decision for themselves. When we talk about liquid damages, this is a separate thing. In Oregon, sellers can only recover liquid damages. Liquid damages should be representative of what the parties expect the reasonable cost of the contract will be to the parties if it falls apart. The idea behind this is, for example, if the house is off market for 30 days, what's the loss to the seller? What is the seller losing if their house is off market for 30 days? And in most cases is your earnest money. It's whatever the earnest money sum is. That's all the seller can get back. If the seller is concerned that the market is super hot and it'll be, 30 days off market could result in, $100,000 in lost value. If the market is in a steep decline and the seller gets an offer and then 30 days later, all the other offers are $50,000 cheaper than the one that you got that first time, that would be a fine example of a damages provision to put in for your earnest money. But with that said, there are limitations to this. Liquid damages can't be a penalty. It can't be something where you're just punishing the buyer to stop them from terminating the contract. That standard comes from a case called Illing versus Bushong. Illingsworth versus Bushong. This is an Oregon case where there was a ranch that sold for $500,000 or was going to sell for $500,000. They put $50,000 down as their earnest money. And then there was a termination partway through the transaction. It was like 15 or 20 days in. And they said, okay, then we're going to keep the $50,000. The seller are going to keep that $50K. The answer is, well, there's no way. And this is in the 80s. This is 83. 15 days off market was not worth 50 grand. That was like a year's worth of operating expenses of the entire ranch. So that was a penalty. It was a punishment. Your seller should know your earnest money should not be a punishment. It should be representative of about what we expect the property to value to decline by over the course of the transaction, or the costs that could be incurred by the seller over the course of the transaction. If you're selling the house and you think, man, this could get expensive because these buyers are a little risky, they're buyers that they were at the open house, they were trying to pluck stuff off the walls and look at it behind the walls. So I think when this buyer's doing their inspections, they might cause damage. That's why we put an extra $1,000 in the earnest money request. That would make it more reasonable and not a punishment. But if you were trying to just penalize the buyer and make it so if they terminate, it hurts, that's not allowed. That's not okay. The seller needs to know when they ask for earnest money, when they're putting an earnest money amount down, it needs to be reasonable. Now, with that, we also talk about where the reasonability comes in. If the contract is terminated very early on in the transaction, the earnest money amount the full earnest money amount might not be reasonable. If, for example, you're 3 days into a transaction and the buyer never deposits the earnest money, 3 days worth of time off market is not worth 5% of the purchase price value, with very few exceptions, rare instances where that would be the case. In general, you want your number for your earnest money, for your liquid damages, to be substantially reasonable, something that would be what it actually costs, the actual damages to the seller in those instances. It's hard to calculate those, which is why we put up liquid damages. We basically say the future is 30 days from now. How are we supposed to know how much it would cost to gain or lose in the market? It could be $10,000. That seems reasonable. If it's reasonable, it's usually allowed. If it's something unreasonable and you're just trying to make it so that they don't want to terminate the transaction, don't put that number down. The reason why this section exists in the advisory is to prevent those sellers that go, well, okay, so I see this buyer's offer. Why don't we just counteroffer and say, you got to put down $100,000 earnest money. When they put that $100,000 down, they're never going to terminate because they don't want to lose that money. you can point to the advisory and say, yeah, that's literally not allowed. That's not how this works. You won't win that lawsuit. And here's the explanation of why. Illingworth versus Bushong, as well as how it was modified by T. Tomaso Realty versus Moak, which is more case law. I won't get into that. Lead disclosure form, also in the advisory, also very important. Federal law creates a requirement that seller has to provide the Protect Your Family from Lead in the Home pamphlet and set a handful of lead disclosures. If the seller of the property is selling a house that was built before 1978, the seller needs to know all of the various disclosures they're supposed to be providing, because if they don't provide them, they can get in trouble. There's additional information that's provided in the advisory about how to contact various people that have that information about lead, the National Lead Information Center, as well as connections to the EPA's websites and the various kind of enforcement processes for lead hazards. Why is it important? Because you can get really, really in trouble if you do lead stuff wrong. This is 2023 from April, is just a couple months ago. A guy in New York got slammed with a massive violation of lead poisoning problems, lead hazard disclosure issues, where he simply didn't tell people, or rather falsely stated that he didn't know about lead. He did. In all 23 of the rental homes he was renting out, he knew about the lead problems and just told them there's no lead problems here. That lie carries a maximum prison sentence of 5 years and a $250,000 fine with it. Now, more likely than not, the guy will get just a year or a bit of prison time, and probably, I'd guess it's going to go to the top end of that, 50 grand or so on how much he's fined. But that's why you want to tell your seller about it. If they know about lead, they should not lie about it, because if that lie comes out, they will get dinged, and they'll get dinged heavily for lead. We don't play around with lead poisoning stuff. So your seller should be informed. They should be aware. They should know the risks involved in lying about lead stuff. In general, they should just not lie, but they should know that lying about lead is serious, very serious. There are also some reasons why we give the advisory that pulls up issues that might not come up otherwise. Like in common conversation, you're not just going to be like, oh, by the way, seller, what are your thoughts on backflow prevention to keep your septic system from like flowing into the well systems? Or how do we keep your non-potable water away from your potable water? Do you ever think about that, seller? Like, what are your thoughts about that? No one talks about backflow prevention. The only people that do that are civil engineers. This is in the advisory so that it comes up and the seller can be aware of it. If the seller goes, I've never thought about that in my life, I've never put one of those things in at all, well, you might need to, because that could be something that becomes a serious problem. If you got irrigation water that's contaminated with pesticide or with herbicides or something like that, and it somehow flows into the well water because you don't have backflow prevention of a sort, that's going to cause issues, and those health problems will blow back on the seller. So giving them information about these esoteric concepts before they become a problem is a great way to prevent sellers' problems in the future. It's preventative maintenance. The same is true for video and audio recordings. There's an entire section on video and audio recordings that basically says, be aware these things can cause problems. Oregon law literally creates a section, ORS 106, I don't remember exactly which one this comes from. There is a crime in Oregon if you invade a person's privacy by knowingly or making or recording motion pictures of another person if they are in a state of nudity without their consent, or if the other person is in a place where they expect to have reasonable expectations of personal privacy. Now, this might sound like I'm making some weird example here, but there are quite a few cases across the nation where someone has, for example, a hidden camera in a room, and they have a recording of the buyer doing or saying something through that hidden camera. Or you've got creepy, weird people that put hidden cameras in bathrooms, and then when people are at an open house visiting the property and they use that bathroom, that seller has committed a crime. So that's why we generally want to inform sellers, hey, heads up, video and audio recording information, not okay, not cool. If you have an open house going on, you should really just probably remove the nanny cam and take it with you. Don't have it in the room and then watch it later on and learn the secret bargaining techniques of that buyer. You want to make sure that you don't have these video recording tools in these places, because you can get in trouble. It's quite literally a criminal act if you are recording someone when they expect to be private. If they are having a private conversation with their spouse about how much they plan to spend on this property, they're in the child's room and they're talking to each other and go, oh, I love it. I want to put $100,000 or $200,000 on this house. I would love to put down 200. We could go up to 250, but I would like to put 200. There are things I'm concerned with, but if we had to, I'd go to 250. The seller learning that information through a video recording camera and then using that is a crime. So sellers, it might sound like a great way to sneak a negotiation in your favor, but don't cause yourself the problems. We put this in the advisory to specifically keep those sort of shady sellers from doing these sort of shady acts. Another thing, and this is the last one I'll point out before the question and answer section, buried oil tanks, those stored oil tanks or subsurface oil tanks or in some case propane tanks. Those can really cause problems for the seller if they aren't paying attention or if they don't disclose that information. If you're a buyer that purchases property that had a for example, let's go in the commercial context is probably the best example. You're purchasing a piece of property that used to be used as a gas station, but you don't know it was used as a gas station. The previous usage is not disclosed. You don't know that there's a tank underground under the concrete surfaces that's been concreted over that had gas in it once upon a time. Your buyer purchases the property, and then several months later, they get hit with a lawsuit from the EPA that says, "Hey, buyer, bad news. There's leftover residue from that gas tank, as well as rusts and various other problems that are seeping into the city's water supply, and we traced it back to your property. It's your property that has this tank." When they crack the ground open and find this subground tank in there, the buyer is responsible as the property owner for the cost of that cleanup, that Superfund site issue. And if you're the seller who didn't disclose that, you're coming in on that lawsuit. So if you know about the oil tanks or the subsurface tanks, then you should disclose that information. Failure to do so can cause some very, very serious lawsuits. And in some cases, these brownfield and Superfund sites can be exceptionally expensive, and the lawsuits will basically mean that the seller is sacrificing 2 to 3 years of their life in lawsuit time just for something they could have disclosed at the outset and bypassed their own role in the lawsuit. That's what I've got. I kind of babbled to you for a while there in the middle. Are there questions that people have? See a Q&A. Security cameras, common around homes these days, including those built into the home automation systems. How do you address that sort of video ability in the home of the seller? So if you have a security camera that is there, the best way to address it is to, I'll go back to the video camera, is to make it clear to the parties that I'll answer this live, to make it clear to the parties that there is a video camera in these places. To say, for example, like, hey, heads up, if you go into the garage, you'll put a piece of paper on the door that says, be aware there's a video camera that's built into the ceiling of this garage. We have a security camera in the garage. So if you're in this room, you're being recorded. If you make parties aware of that, they no longer have a reasonable expectation of privacy. So disclosure removes the reasonable expectation of privacy. Now, if you have a security camera, like a home automation camera, that puts the camera in a bathroom or a place where someone might be in a state of nudity, that's a problem, and you probably need to remove those or turn those cameras off or find some way to not make that a problem. But the typical situation where someone would be in a place where they're expecting to be private but they're being recorded, the way to ensure that you don't get in trouble as the homeowner, if you can't turn those cameras off, remove them, get rid of them, that kind of thing, take the nanny cam with you, is to say, hey, parties, if you are in this space, you are on candid camera. So be aware if you're on candid camera and it records audio. So if you're going to be talking about things, or if you're going to be like doing something shady, or this is not the place to use some sort of illicit drug. This is not the place to talk about your bargaining strategies, because you are being recorded audio and visual in this area. That removes the reasonable expectation of privacy. Other questions? That's a good one, but other questions? If anybody's got them, that's I'll stay here for another 5 minutes. But otherwise, we got you to 10:55. Our CE will be sent out within 2 to 3 weeks or so. I release you out to the world if you don't have questions. Otherwise, I'll stay on for the next 4 or so minutes. And if anybody's got questions, we can answer those and address that. We'll also post these videos up on orforms.org. Let me pull up for informational purposes. On orforms.org on training, we post up all of our, oops, wrong one, that's live courses, recorded tutorials. So over time, we'll post up these videos on here as well. And you can watch it at like 75% speed, so you don't have to deal with my super fast chatter. Try not to get overkills on cameras. Can you have a document to sign before people tour a home disclosing that information? Yes. So Cynthia, that is another way that you could do that, is by doing what amounts to a waiver form. If parties are going in and you say, okay, you are aware by walking onto this property, there are cameras in various rooms in this house, and don't do anything private, don't do anything sketchy, don't talk about things you don't want to be recorded. You could have people sign that before they go into the house, and that's one other way to do it. In essence, that's the same thing as having a notice posted up in a visible place. It essentially is just giving the party, it's saying a reasonable person would now be aware that this is you're being recorded, so you don't have a reasonable expectation of privacy. Absent a statement, they might have a reasonable expectation of privacy. When you've made a statement or put up a notice or made it obvious, or if the camera is like super obvious, it's one of those CCTV cameras that's just there and it's moving around all the time and everyone knows it's a camera, you probably don't have a reasonable expectation of privacy. The question is the reasonability. It's a lot of pages. How do you present pages without printing them out when you're sitting with the client? So it is a good question. One way that you can do it without printing it out would be to go onto the website. So to have a laptop in front of you, where you go to the Oregon Realtors buyer and seller advisory, and you say, okay, let's say we're doing seller advisories today, so seller, they're a seller. You'll pull up exactly this on a laptop with the client, or have them pull it up on their laptop, and you'll walk through it on the laptop rather than printing it out. Now, with that said, if you don't print it out, the downside you have is you have to assume that you make sure your client walks away with the exact email address or the way to find this advisory so they can reference it into the future. And the thing that you would absolutely want printed out is that last page that says, I acknowledge that I got this document, or that I've learned about these things. So you would print out this last page because that's for your file, but you can pull it up on a laptop or on a computer and walk them through the document one step at a time without having to print it out as well. Any other questions? Or if not, we've gone all the way to 11 o'clock, and it's officially your Friday, and I hope you all have a wonderful weekend.